Partnerships are great for buying real estate. They're efficient vehicles for holding and owning and managing real estate. But when it comes time to sell, there isn't any elegant exit for the individual partners. Who has owned the property, the real estate, the partnership? The constituents or partners inside of that entity don't own an interest in real estate. And partnership interests were excluded from 1031 treatment. So this is the biggest planning opportunity, to figure out your elegant exit before you list the property for sale. Again, the aristocrats, the high-level thinkers in the 1031 industry, think about this concept of qualified use, the holding period. If I distribute out your partnership interest to you, and you now own an undivided 1/7 of the property because you owned 1/7 of the partnership, how long must you hold that property, hold that real estate, before you are eligible to do an exchange? There is a debate going on in the highest levels of 1031 thinking. Some tax practitioners think that you can tack the period of time that the partnership owned the property to the period of time that you owned it. And so that you can immediately just do an exchange after distribution out of the partnership. Other practitioners think, well, you just held it for a millisecond. How can you say that you held it for investment or business purposes? Because you immediately sold it right after you got it. And oh, by the way, the entire time you held it, it was subject to a purchase agreement negotiated by the partnership to sell the property, that this was just a continuation of the partnership's activities. The high-level thinkers that think that he can drop and immediately swap rely on this case called Magnuson. Magnuson, though, was a case where a guy did an exchange, and then he immediately contributed his replacement property to a partnership. And the IRS said, hey, you can't do that. And the tax court allowed it. But in those days, this case was decided, Magnuson was decided on facts and law that don't exist any longer. This was pre-84, prior to partnership interests being excluded from 1031 treatment. So the tax court probably took a more liberal view. Oh, you're just continuing your investment in the modality of partnership modality, no big deal. That's different law than we have now. I don't think Magnuson is a credible authority to rely on. I think it's a suspect, dubious authority to do major tax planning on. But reasonable people are going to differ in their interpretation of what to do. My advice is to get with your tax attorney, build your team, and break up, reconfigure, reorganize the ownership of your partnership assets early, well before you've listed the property for sale, well before you've signed a sale contract, reconfigured the ownership. That'll be the strongest and most defensible position. Right now, if you're in California, the FTB, the Franchise Tax Board, most erratic, most aggressive taxing authority, they're going after these drop and swaps. But they're much more liberal and accepting of a pre-planned partnership division where we spin off subsidiaries and drop the real estate into these entities that are considered continuations of the predecessor for tax purposes, sometimes referred to as a 708 spin-off. That's being more accepted by the California Franchise Tax Board. Maybe if I'm in the western states, I'm going to be more thoughtful, pre-planning, and orient myself towards that kind of reconfiguration rather than a crude drop and swap. If you drop down out of your partnership to a tenancy in common and you don't notify the bank or get their consent, you're technically in default of your due on sale clause. which is not a problem if you don't have a bank lender, but if you own encumbered property, you should probably ask the bank. You should probably change your insurance with your insurance provider, because now the partnership doesn't own it anymore. The insured should be the individuals. Your accountant should be notified immediately that you've dropped out of the partnership. Stop the 1065 bookkeeping and tax reporting. Henceforth, you're going to be reporting this income on Schedule E as individual income, not K1 partnership activity. So there's a lot of things that you have to do to affect a real exchange. Bottom line, 1031 is a great tool for deferring your gain. Without the drag of taxation, you can amass and build an enormous amount of wealth using and redeploying the money that you otherwise would have paid to the state and federal government in taxes, keeping all of that money compounding and building and working for you. And the ability to use OPM, other people's money, U.S. banks' money, leverage, supercharges your ability to build wealth in real estate. The thing to remember is, as you parlay from one property to the next, you're taking that deferred gain with you. Your basis in the replacement properties will be lowered by the amount of gains that you didn't recognize on your previous sale or sales. So you're building up this deferred gain. You're carrying that baggage with you. All right? You started with a single family, you parlayed it to a fourplex, you parlayed that to a 12 unit, you parlayed that to 32 units. Eventually you're up to 64 units. Is it conceivable that you could do that over the course of 30 years? Is it conceivable that you could do it over the course of 20 years? I know people that started in the 80s and they're up to like 5,000 units. It's crazy how fast you can parlay this equity when you're not dragged down by taxation and you're able to supercharge it with other people's money. All right, now you've amassed all of this real estate wealth. You've got all this deferred gain. What are you going to do? Defer, 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 die, because Section 1014 allows for a step up in basis. When you die and your heirs inherit that property, they receive the property not with your low basis, Dad. They get it with a stepped up basis. It steps up to the fair market value at the time of the decedent's death. Now, you may have other issues like estate tax, inheritance tax, so you should have your team helping you. How do you fix an estate tax problem? You buy life insurance. When you're young and healthy, Mr. Plaid Shirt Dude, this is when you go in and see your life insurance person, because you can pass a medical. You don't have high blood pressure. You know, if you smoke, stop smoking. Get that life insurance while you're young and healthy, because you might need it to fix a problem down the road.